Hi, in this video, we will understand the IRAC with mock exercise. As you might know that the exam for the subject will be a 3-hour open book exam. It may consist only of problem questions or it may consist of a mix of problem questions, short answer questions and short essay questions. A typical problem question will describe an actual or fictional statute or any other government action, and the NCA will ask the candidates to assess whether it is consistent with the provisions of the Constitution Act 1867 or the Constitution Act 1982, and if not, what the consequences are likely to be. These problem questions tests your ability to identify constitutional issues, accurately state the applicable legal rules, apply those rules to hypothetical situations, cite relevant case laws, and draw conclusions supported by the analysis. Secondly, NCA strongly discourages the candidate from copying out prepared study materials. So in this video, I will tell you how to frame an answer in IRAC pattern when a problem question is given. But before that, for your convenience and better understanding, I would like to discuss the concept of doctrine of paramountcy. It is the topic 10 of your syllabus of Canadian constitutional law. Now come to the doctrine of paramountcy. The doctrine of federal legislative paramountcy dictates that where there is an inconsistency between validly enacted but overlapping provincial and federal legislation, the provincial legislation is inoperative to the extent of inconsistency. Basically, under this doctrine, a provincial law that conflicts with federal law will be inoperative to the extent of the conflict. This means the federal legislation takes precedence over the provincial. Therefore, when there is a conflict between a valid federal law and a valid provincial law, the federal law prevails. So the doctrine of paramountcy comes into picture when there is an express contradiction between federal and provincial laws, and there is an impossibility of dual compliance, that is, when it is impossible to comply with both laws simultaneously and where the provincial law is actually frustrating the purpose of the federal law. The case of Rotmans, Bensons and Hedges Limited versus Saskatchewan 2005 is a significant illustration of the doctrine of paramountcy in Canadian constitutional law. This case involved a conflict between a federal law and a provincial law regarding tobacco marketing and regulation. Now coming to the Rotmans, Bensons and Hedges Limited versus Saskatchewan 2005, the Supreme Court of Canada established a two-step test for determining the application of the doctrine of paramountcy. Here the two-step test was a dual compliance test and a frustration of purpose. Now let's understand what is dual compliance test. In dual compliance test, one has to check, can a person comply with both laws simultaneously? In frustration of purpose test, the court will check, does provincial law frustrates the objects of the federal law, even if compliance is possible? Now, while applying this two-step test in any situation, if the answer to the dual compliance test comes yes, that is, if it is possible to comply with both the laws at the same time, and the answer to the frustration of purpose test comes no, that is, the provincial law does not frustrate the objects of the federal law, then both the laws stand operative. But in case the provincial law frustrates the purpose of the federal law, then the doctrine of paramountcy will apply and the federal law will prevail, rendering the provincial law inoperative. Now see, this is a mock exercise that we will discuss today based on the doctrine of paramountcy. So that's why we discuss doctrine of paramountcy in today's lecture. Now read the facts very carefully. The federal government of Canada recently enacted the National Consumer Protection Act, that is NCPA, which regulates product labeling standards across Canada. The purpose of this legislation is to provide consistent and clear information to consumers regarding the health and safety of products, including mandatory labeling of ingredients, allergens, and expiration dates. Under this law, all processed food products must meet a uniform federal standard for packaging and labeling. Meanwhile, the province of Alberta has enacted its own law, the Provincial Health and Safety Standards Act, that is PHSSA, aimed at promoting consumer health by mandating stricter food labeling regulations. Under the provincial law, all the food manufacturers must not only comply with the federal labeling requirements but also include additional information such as the carbon footprint of the product, fair trade certification, and an extended list of potential allergens. A large food processing company, Healthy Choice Foods Incorporation, which operates across Canada, argues that complying with both the federal NCPA and provincial PHSSA would be unduly burdensome and that the two sets of regulations conflict. The company files a legal challenge asserting that stricter provincial requirements make it impossible to comply with both federal and provincial laws without significant cost increases and operational complexity. Now, the company contends that the federal law should prevail, rendering the provincial law inoperative under the doctrine of federal paramountcy. The provincial government of Alberta, however, argues that the two laws can coexist and the provincial law is simply imposing higher standards for the sake of public health. Now here, assuming the validity of both the NCPA and PHSSA, is PHSSA inoperative? Let's frame our answer in IRAC pattern. So starting with issue, we can form an issue in the words, does the Provincial Health and Safety Standards Act, that is PHSSA, have the effect of limiting the National Consumer Protection Act, that is NCPA? Now coming to the rule, here we will see whether the doctrine of paramountcy will apply, whether the tests laid down in Rotman's, Benson's and Hedges versus Saskatchewan case are fulfilled. Mentioning these points, we will go to the analysis part. In starting our analysis in the words, in the given scenario, NCPA aims at providing consistent and clear information to consumers regarding the health and safety of the products with uniform federal standard of packaging and labeling of all processed food products. Similarly, PHSSA also aims at promoting consumer health, mandating to comply with federal labeling requirements and imposes additional labeling requirements in Alberta. Applying the two-step test laid down in Rotman's, Benson's and Hedges versus Saskatchewan 2005 in the given situation, the fact that PHSSA adds extra requirements and does not contradict the federal standards, the Healthy Choice Foods Incorporation can meet both the federal standards and the additional provincial requirements. Here the first step of Rotman's criteria is satisfied because it is possible to simultaneously comply with both the laws. Now coming to the second step of the Rotman's test, however not satisfied because by PHSSA the provincial government is in effect not frustrating the federal government's ability to fulfill the objective of NCPA. Further, the doctrine of paramountcy comes into picture where there is an express contradiction between the federal law and provincial law and there is an impossibility of dual compliance and the provincial law is actually frustrating the purpose of the federal law. Here in the given scenario, neither the NCPA and PHSSA contradictory nor PHSSA frustrates the purpose of the NCPA. Now, while drafting your analysis part, remember one thing, that whatever case law or whatever section or whatever doctrine you mention in the rules part should be discussed in the analysis part also. Now, while writing the conclusion, you can frame it in a sentence or two. Like in this mock exercise I have drafted, in the light of above analysis, it can be concluded that the provincial law, that is PHSSA, does not contradict with the federal law, that is NCPA. Hence, both the laws can be operated simultaneously. Hope the video was informative. So, all the best for your NCA Canadian Constitutional Law exam. We will meet in the next video with a new topic. Till then, goodbye. Thank you.